everybody. I would like to welcome and thank you for joining us here at the Economic Club of Las Vegas, where we are welcoming Erwin Chemerinsky, the Dean of the School of Law at the University of California, Berkeley. The Economic Club of Las Vegas is a nonprofit, nonpartisan forum for economic discussion. We bring experts on regional, national, and international issues to our Las Vegas audience, allowing us to hear from them and offer our own questions and ideas in return. The club was formed in 2013 and is also an affiliate chapter of the National Association for Business Economics. Before we begin, I would like to recognize the hard work of our board and officers. Without their commitment to the club, these events would not be possible. I would also like to thank our sponsors for their generous support, both in terms of financial support and also in helping us spread the word about our events. Today's discussion focuses on the latest developments to the Supreme Court and the likely effect it might have on key and controversial issues. But in light of this week's shocking events in the Capitol, we know that there is a lot to discuss. Dean Chemerinsky brings his expertise and experience that includes authoring over 11 books, including leading case books and treatises about constitutional law, criminal procedure, and federal jurisdiction. He is the author of more than 200 law review articles, and he writes a regular column for the Sacramento Bee. We are honored to have him join our discussion today, and I would like to let everybody who is tuned in right now to know that at any time during the event, feel free to submit any questions that you may have via our chat button. Our moderator and club president, Ken Heck, will organize and present all the questions to Dean Chemerinsky. Thank you again for joining us, and please enjoy the conversation.
Well, good morning, everybody, and thank you for attending. Dean Chemerinsky, we really appreciate you generously sharing your time with us. It is a very, very hard time to consider what's going on with our country, and to feel extremely proud of our government. It's a really hard week to have this conversation, and I had a whole series of questions talking about the Supreme Court and key issues that were coming before the court this year. But instead, why don't we go ahead and let's just hit the really hard stuff. Okay, so now that the Electoral College has confirmed President-elect Biden's his success in the election, and after the protests at the Capitol building, the first questions I'm being asked by everybody else, and I'm going to let them have it right away, is will there be repercussions for Senators Cruz, President Trump, or the mob themselves?
First, let me say what a pleasure it is to be part of the conversation. Thank you for inviting me. I think you need to break down each of the people or groups that you talked about. As for the mob that broke into the Capitol, there need to be criminal prosecutions. We know that a guard was killed during this process. We know that others were injured by it. It at the very least was vandalism of federal property and disrupting Congress in session, but it also involved death. Unfortunately, relatively few people were arrested on Wednesday, and there should be an investigation as to why that was so. But I understand that now the FBI is using pictures and tracking down people, and there need to be prosecutions. What occurred on Wednesday in the breach of the Capitol was not speech. It was not protest protected by the First Amendment. It was violence, and as both Republicans and Democrats have said, it was insurrection. The second group you identify, and it's where you began, was the senators, and for that matter, the 133 representatives who voted to overturn the results of the Electoral College, or at least have a commission and delay the certification of Biden as president. They violated no law. I think that they acted to subvert our democracy, but any consequences for them is going to have to be through the political process. The next time they run for office, I hope that people will consider that they tried to undermine the results of the popular election electoral college. Finally, there's President Trump. There are many things that could happen. Obviously, there's the possibility that the vice president and the majority of the cabinet could choose to invoke Section 4 of the 25th Amendment, deem President Trump unfit to perform the duties of office, and have Vice President Pence perform those duties until January 20th. From all we know, that seems unlikely. Second, there is the possibility of an impeachment by the House of Representatives. Speaker Nancy Pelosi has said that could go forward as soon as the middle of next week. Whether the Senate would come back to try him is an uncertain question. As of now, the Senate is in recess until January 19th. Whether an impeachment or removal process could continue beyond January 20th is unknown. Article 2 of the Constitution says the president can be removed from office for treason, bribery, high crimes, and misdemeanors. If he's not in office, can there still be an impeachment? We've never faced that question before. There is certainly the possibility of a criminal prosecution of Donald Trump for incitement. The United States Attorney in D.C. said it's one of the things being investigated. Whether the president can be criminally prosecuted after leaving office for things that were done while in office, there's no answer to that question. Can President Trump pardon himself? We have no answer to that question. No president has tried to do that. I don't think a president can pardon himself. Article 2 says that the president can grant pardons and reprieves. That implies it's something bestowed on others. Also, in Anglo-American history, in world history, there aren't examples of pardons being self-granted. To me, the rule of law is that no one, not even the president, is above the law, and a self-pardon would put the president above the law. But we don't know because it's never been tried. So that's why I think if we talk about consequences, we really need to break it down in terms of who we're discussing.
So let's start first and foremost with the easiest people, the private citizens who participated in the insurrection. There's been some conversation that they might be tried and they might be prosecuted. What is the possibility or likelihood that President Trump would actually step in and, as you mentioned, pardon them?
I hope not. President Trump has the power to pardon anyone accused or convicted of a federal crime. President Trump could give them a pardon as to all federal offenses that were committed on Wednesday. Since D.C. is a part of the federal government, those would be considered federal offenses as well. We know that on Wednesday, President Trump described them as patriots. He expressed his love for them. Yesterday in a video, President Trump had a very different tone. I think it would be a travesty if President Trump issued pardons to those who breached the Capitol of the United States. It's the first time that's occurred since the War of 1812, when England burned down the Capitol in 1814. What we saw on Wednesday, we've never seen before. Someone died, a guard was killed as a result of it. Damage was done to the Capitol. I think it would be terribly unfortunate if President Trump would pardon those individuals. But does he have the power to do so? Yes.
So, which brings me to the next question, because let's continue going down this line. Let's talk about the senators who were and the congressmen and women who were involved. And I'm not talking about the 133. I'm talking about the people who are being discussed in the mass media as inciting insurrection, the Giulianis, the Cruzes, these types of people who were a little more headline. What is the likely response regarding them?
Again, I think you need to separate the individuals. If you look at the statements of Rudy Giuliani on Wednesday, they come as close to being incitement as one could imagine. He very much was encouraging exactly what happened. I don't know that Ted Cruz made such statements. He certainly said that he favored a commission to consider whether there's electoral fraud and wanted to delay the Congress certifying the results. I don't know if he made statements that might be thought of as incitement. Incitement, by the way, we should talk about that. It's very difficult to prove. The standard for incitement under the First Amendment is there has to be a substantial likelihood of imminent illegal activity, and the speech must be directed at causing imminent illegal activity. I think when you look at Giuliani's statements and also look at Trump's statements, there's an argument that they meet even that very difficult standard for incitement.
I'm walking a very fine line here, and I recognize it. Can you talk to me about there's some conversation about Rule 34 and this whole concept that the transition of power could be delayed as a result of the insurrection of this past Wednesday.
No, the inauguration cannot be delayed. The Constitution specifically says that a president's term ends at noon on January 20th. Donald Trump's term will end at noon on January 20th. Congress has certified the results in the Electoral College. Joe Biden will be sworn in at basically noon on January 20th. I do not see any basis that there could be a delay in the inauguration of the new president.
Thank you for that very clear answer. By the way, keep those questions coming in. I will absolutely work them into the conversation as I can. So thank you very much. And Erwin, Nancy Rappaport says hi.
I'm a huge Nancy Rappaport's dad.
We all are. She's on the board of this club, so we're a big fan. Okay, so back to it. One of the questions I have is, what tools does the Supreme Court have in the form of checks and balances that might address potential excesses from the other branches?
What's important to remember is the Supreme Court can act only if a case properly comes to it. It's not a roving commission. It could play no role this week, even if it wanted to, because there wasn't a case there. On the other hand, the Supreme Court has the ability to declare federal laws unconstitutional and has the ability to declare executive acts, including by the president, unconstitutional. Also, the Supreme Court can declare state and local laws and acts of state and local governments to be unconstitutional. This is an enormously important power. It's familiar to all of us, and yet the Constitution doesn't say anything about it. The Constitution doesn't mention the power of the courts to declare laws or executive actions unconstitutional. It all came from a Supreme Court decision in 1803, Marbury versus Madison.
So the Supreme Court enabled itself to empower itself to declare things unconstitutional.
Some believe it was always implicit in the structure of the Constitution. Some believe it was never meant to be. There's been that debate ever since early in American history, but the reality is the power of judicial review has existed now for over 200 years, and it's a well-established and accepted part of American government.
Well, then I too will accept it. So that begs the question then, what is the likelihood of the Washington, D.C., of the federal attorney general bringing cases before the Supreme Court? And are they going to have to wait in line, or are they going to get prioritized? And what cases are we likely to see from this week?
Okay. What's important to remember is, with rare exceptions that have no application here, any matter to come to the Supreme Court has to start in the federal district court or in a state court. So the federal district court, it has to go to the Federal Court of Appeals and then go to the Supreme Court. In rare situations, the Supreme Court can take a matter before the Federal Court of Appeals decides it. And it has to go, if it's in state court, all the way through the state system to get to the US Supreme Court. Are there matters that have arisen that we've just seen that might get to the Supreme Court? Sure. Imagine that there's a prosecution of those who are involved in breaching the Capitol, and they have some defense. Ultimately, after they're convicted and it goes to the Federal Court of Appeals to go to the Supreme Court. Or imagine that Donald Trump is criminally prosecuted for incitement. He could try to argue that a sitting president cannot be indicted for conduct in office. There's no resolution of that issue yet. And that could ultimately make its way to the Supreme Court. But when the Attorney General wants Supreme Court review, it's the same as you or me or anybody else, has to start in a trial court, generally go to the Court of Appeals, and then go to the Supreme Court. There's no ability of the Attorney General to just go right to the Supreme Court.
I see. Which branch of government has the ability, or is there any branch of government that has the ability to sequester Trump's ability to start war or unleash some sort of germ warfare or use a bit? It's a tough question, but I'm asking it.
Sure. Under the Constitution, the president, so long as in office, is the commander-in-chief. The vice president and a majority of the cabinet, under Section 4 of the 25th Amendment, could deem President Trump unfit to perform the duties of the office. President Trump then could be removed. Obviously, there is possibility that if President Trump were to issue an order, like to launch nuclear weapons or biological attack, the military could choose not to obey such an order, and we'd have a constitutional crisis. But technically, so long as somebody is the president, that individual is the commander-in-chief of the military.
Okay, so I think what I'm going to sum up what we've heard about this week is that the Supreme Court can do nothing until a case is brought before it to answer these questions. The president can issue pardons. So here's a question: can Congress or the Supreme Court or anybody overturn a pardon from the president?
No, the president has the power to pardon anyone accused or convicted of a federal crime. It's important to emphasize the president's power is only as to federal crimes. The president cannot issue a pardon as to state law crimes. One of the questions in the chat is whether the president can pardon himself. We don't know, because no president has ever tried to do so. But I think there's a strong argument, as I said, that the president can't pardon himself, that the language of Article 2, the president grant pardons, implies it's bestowed on others. That's always been the historical practice, and otherwise it would put the president above the law. But can the president blanket pardon the insurrectionists so long as he can identify who they are? Can he pardon his family? Yes, he can pardon his family. I think the only open question is, could he pardon himself?
Okay, so what we're hearing, though, is that the question is, what is the likelihood of prosecutors delaying bringing these charges until after President-elect Biden is in office?
The United States Attorney can charge individuals at any point in time within the statute of limitations. And of course, there's no statute of limitations for murder. Some people have already been charged. My guess is, just given how long it's going to take to figure out who was involved, some won't be charged until after January 20th. And I had not thought about it, but it's conceivable the U.S. Attorney could wait to bring some charges until after January 20th, take away the possibility that President Trump could pardon them.
Yeah, I think, to me, if I'm sitting in the Attorney General's office and I'm concerned about that, that seems like the right way to go so that they can have a fair and unfettered legal process. Okay, so I'm gonna close the conversation about pardons. Otherwise, we could be going down this rabbit hole for an hour and a half, 2 hours, and we don't have that kind of time today. I do have a question, is that if there was, let's say the insurrection had been a little bit more successful than it was, what is the judiciary's role in the event of, say, the fall of one of the houses of Congress or even of the executive branch?
Thankfully, it's never happened in American history. We don't know. I'm not sure what it means to speak of the fall of one of the houses of Congress. Imagine a situation where on January 20th, Donald Trump would refuse to leave office and say, I won the election I'm going to stay, and Joe Biden gets sworn in, then I could imagine a role of the court in saying, no, the Electoral College decided the election, Congress certified it, Biden is the president, you have to go. I don't know what would happen if insurrectionists really took over the Capitol and tried to run the government. My guess is that the Supreme Court would try to weigh in and say, no, the House of Representatives, the Senate, are those who were duly elected by the people, and they're the ones who get to exercise the power. I guess the only thing I'd say is, thankfully, we've never seen it in this country, but we've seen things like that in other countries. So we shouldn't think that it's something that could never happen here.
Thank you. Okay, so I'm gonna dial down a little bit of the stress, and we're gonna move on to some of the more important issues that are not relating to this week's, thankfully, failed insurrection. There's been conversation that over the last 4 years, there's been a significant change in the leaning of the Supreme Court more towards the conservative side. Is this really the most conservative court we've ever had?
This Supreme Court is as conservative relative to the issues of this time as any Supreme Court has been relative to the issues of their times. Or to put it another way, this is the most conservative Supreme Court we've had since the 1930s. How did it happen? Well, since 1960, we've had 32 years of Republican presidents and 28 years of Democratic presidents. So it's been almost even, and in 4 years, we'll have had 32 years of Democrats and 32 years of Republicans. But during this time, Republican presidents have picked 15 Supreme Court justices, and Democratic presidents have picked only 8 Supreme Court justices. And what we've seen is that the Republican presidents in recent years have picked very conservative justices when you think of the ideological spectrum. If you think of our country being from very conservative to very liberal, we have right now 5 very conservative justices: Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. We have 1 moderate conservative justice, Roberts. We have 2 moderate liberal justices, Breyer and Kagan, and 1 very liberal justice, Sotomayor. We had 2 until Justice Ginsburg passed away. But that does create the most conservative court that there's been since the 1930s, and as conservative a court as there's ever been in American history.
And still last year, after Kavanaugh and Gorsuch were appointed, the Supreme Court did, on Bostick versus Clayton, vote to include sexual preference as a protected class. And that, I think, was a 6-3 vote. So on which topics should we expect to see the conservative nature of the Supreme Court weigh in?
Last year, the Supreme Court decided 53 cases with signed opinions after briefing and oral argument. There were 14 5-4 decisions. In 10 of them, the majority was Roberts, Thomas, Alito, Gorsuch, and Kavanaugh. In 2 of them, the majority was Roberts, Ginsburg, Breyer, Sotomayor, and Kagan. So it was a conservative court before Justice Ginsburg passed away, but replacing her with somebody from the opposite end of the ideological spectrum made it an even more conservative court. You're right. In Bostock versus Clayton County, Georgia, the Supreme Court ruled 6-3 that Title VII prohibits employment discrimination based on sexual orientation, gender identity. Where will we see the court be more conservative? Abortion rights. Last term, one of the cases was about abortion. There's a case, June Medical Services versus Russo. It struck down a Louisiana law that said that in order for a doctor to perform an abortion, the doctor needed to have admitting privilege to the hospital within 30 miles. The majority was Breyer, Ginsburg, Sotomayor, and Kagan. Roberts concurring in the judgment, agreeing to the result but not the reasons, and Thomas, Alito, Gorsuch, and Kavanaugh dissenting. This year, with Barrett instead of Ginsburg, that would have come out the other way. I think there are now 5 justices, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, to overrule Roe versus Wade and to end constitutional protection, the right to abortion. I think we are going to see much less in the way of protection for gay, lesbian, and transgender individuals. In 2015, in Oberfeld versus Hodges, the Supreme Court ruled 5-4 that state laws that prohibit marriage equality deny equal protection and violate the right to marry for gays and lesbians. Roberts, Thomas, Alito, Scalia dissented. Roberts, Thomas, Alito are still on the court. In 2017, Justice Gorsuch wrote a dissent in Pavan versus Smith, where he indicated his strong disagreement with Oberfeld. When she was a law professor at Notre Dame, Amy Coney Barrett expressed her strong disagreement with Oberfeld. I don't know that the court's going to overrule that decision, but it's certainly not going to extend protections for gay, lesbian, transgender individuals. I think what we are going to see is a court that's going to dramatically expand religious freedom, including the ability of people to discriminate against others on account of religious beliefs.
So let's talk about that. One of the important things in our government over the last several hundred years or so has been the separation of church and state. What do you think is the likely progression of that concept?
The idea of a wall separating church and state comes from the words of Thomas Jefferson. He said that there should be a wall that separates church and state. And the idea behind it is, to the greatest extent possible, our government should be secular. That the place for religion is in our churches, synagogues, our mosques, our homes. But now we have, I think, 6 justices who reject the idea of a wall separating church and state. They believe that the government violates the Establishment Clause only if it coerces religious participation. What's this going to mean? There aren't going to be constitutional limits on religious symbols on government property. In 2019, there was a Supreme Court case, American Legion versus American Humanist Association, that upheld a 45-foot cross prominently displayed on government property at a busy intersection in Prince George County, Maryland. I think the court's going to allow much more religious presence in government activity. There's a case a few years ago, Town of Greece versus Galloway, where the Supreme Court 5-4 upheld a town inviting Christian clergy to deliver prayers before town board meetings over a period of 10 years. And they were delivering very explicit Christian invocations. I think we're going to see a court that's not going to allow much more government aid to religious schools, but require it. For decades, the issue is, when can the government give aid to religious schools without violating the Establishment Clause? In the last few years, including this one, or in 2020, the Supreme Court said the government is constitutionally required to provide aid to religious schools when it gives it to secular schools. So no longer is there a wall that separates church and state.
Originally, when the Supreme Court was created, there were 9 districts, and each had their own representative. Now there are many, many more districts, and yet we still only have 9 judges. Where is the country with the argument that maybe there ought to be more, especially considering the fact that there is a bottleneck with the number of cases that the Supreme Court is able to manage?
Just in terms of the history, when the country formed, there were 5 justices on the Supreme Court. The country was divided into 5 areas, and each justice was assigned overseeing one of those areas. And in fact, they would go to that area to function as a court of appeals judge. And it was said they were, quote, I don't know what to do.
Dean, I'll tell you what, you're back.
I'm back?
You just froze briefly as you were describing how the Supreme Court judges would go to their districts to work as the appeals judges.
Okay, so they were called circuit courts of appeals. I'm so sorry for the internet. I generally have not had problems at home with it. When the country grew, they added new territories and an additional justice for each new area. And it actually got up to 10 justices by the 1860s. There was a terribly unpopular president in the late 1860s, Andrew Johnson, even impeached, and Congress did not want him to fill a vacancy on the Supreme Court. So Congress said the next time there was a vacancy, they would eliminate the seat on the Supreme Court. They just eliminate that justice position. And so it became 9. And it's been 9 justices ever since the late 1860s. 9 is just a historic accident. But in 1937, President Franklin Roosevelt tried to expand the size of the Supreme Court. It was labeled court packing, and it was roundly rejected. There's certainly talk of expanding the size of the Supreme Court now. I don't think it's likely to happen. I think the Republicans in the Senate would surely filibuster it, and already some of the more moderate Democrats have said they won't abolish the filibuster. In terms of they're about to elect the Supreme Court last year decided only 53 cases. Generally, the Supreme Court now is deciding in the mid-60s. In the late 1980s, the court was averaging 160 decisions a term. The court can take on a lot more work.
Okay. All right. So thank you for that. So what do you think is the likelihood? Now, we talked about the conservative leanings. We talked about certain events that are going to be, or cases that are coming forward. I'm going to talk about some specific issues, and I love the questions that are coming, and I'm going to include those in the issues. But before we do that, I want to talk a little bit more about the composition of the Supreme Court currently. Are there any justices likely to step down during President-elect Biden's term to reduce the chance of an appointment that could swing in the other direction? And in the past, you have actually suggested that Justice Breyer might be stepping down. Alternatively, well, I guess there is no, we just discussed the idea of adding justices. So what do you think is the likelihood of people stepping down?
Justice Breyer is 82. He'll be 83 in August. I will urge in my op-eds that he consider retiring. In March 2014, I wrote an op-ed in the Los Angeles Times encouraging Justice Ginsburg to retire. I said it looked like the Republicans were going to take the Senate in November 2014. They did. I said there was no way to predict what was going to happen in 2016. That was a great understatement. And I said if Justice Ginsburg wanted someone with her values and her views to take her place, she should step down then. I got an enormous amount of pushback on that, including from Justice Ginsburg. And yet, of course, what we saw was that because she didn't, President Trump was able to replace her with Amy Coney Barrett. I expect many will urge Justice Breyer to step down in the next 2 years when there'll be a Democratic effective majority in the Senate and a Democratic president. We can't know what's going to happen in the November 2022 midterm elections in terms of the composition of the Senate. In terms of the conservative justices, well, I'll start with the youngest. Amy Coney Barrett is 48 years old. If she remains on the court until she's 87, the age at which Justice Ginsburg died, she will be a justice until the year 2059. Neil Gorsuch is 53. Brett Kavanaugh is 55. John Roberts is 65. Sam Alito is 70. Clarence Thomas has been on the Supreme Court since 1991, but he's only 72 years old. I think the best predictor of a long lifespan is being confirmed for a seat on the Supreme Court. So it's possible that we're going to have these 6 justices, or at least 5 of them, for another decade or 2.
All right, so let's get into some topics. Someone did ask a question. I want to ask it. What is the likelihood of the conservative nature of the Supreme Court undermining voter rights?
In 2013, in Shelby County versus Holder, the Supreme Court declared unconstitutional a crucial provision of the Voting Rights Act of 1965. That did undermine voter rights. I hope that now with the Democratic president, Democratic Congress, they will try to recreate and reinstitute a form of the Voter Rights Act. But there's a real chance that the Supreme Court could strike that down as well. So I think the best thing right now would be for Congress to adopt laws to expand protection for voters' rights.
Erwin, the biggest health and economic issue in the United States right now is COVID-19. which cases are on the docket or expected to be added to the docket that might affect the government's response to the pandemic once President Biden is inaugurated?
Already, the Supreme Court has handed down orders in 3 cases concerning COVID-19, closure orders, and religious institutions. There was a case in May, South Bay Pentecostal Church versus Newsom, that involved Governor Gavin Newsom saying that places of worship could not have more than 25% of usual occupancy, more than 100 people. And the Supreme Court 5-4 ruled in favor of Governor Newsom. There wasn't briefing and oral argument. There was no majority opinion, but Chief Justice Roberts wrote an opinion. He was joined by Ginsburg, Breyer, Sotomayor, and Kagan, urging deference to government officials to take action to stop the spread of a communicable disease. In July, there was a case coming from Nevada, the Calvary Dayton Valley Chapel versus Sisolak case, that involved the governor of Nevada's order that limited gatherings for religious worship. And the Supreme Court 5-4 upheld it. The majority again was Roberts, Ginsburg, Breyer, Sotomayor, and Kagan. And Justice Alito wrote an angry, sarcastic dissent joined by Thomas, Gorsuch, and Kavanaugh. But on Wednesday night, November 25th, the night before Thanksgiving, just a few minutes before midnight, the Supreme Court issued an order in Diocese of Brooklyn versus Cuomo, where the court struck down limits on gathering for religious worship that had been imposed by New York Governor Andrew Cuomo. The majority was Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. Roberts, Brierson, and Kagan dissented. What was the difference between the earlier 2 rulings and this one? Replacing Ruth Bader Ginsburg with Amy Coney Barrett. There are many, dozens and dozens of lower court cases involving COVID-19 and the Constitution. In fact, last semester I taught a seminar called Civil Liberties in a Pandemic for our first-year law students. This semester, that starts a week from Monday, I'm going to teach the same thing for upper-level students. And we go through some of the cases. For example, businesses have brought challenge to closure orders. There have been challenges brought to quarantine and restriction on travel orders. There are countless cases brought by prisoners, immigration detainees seeking release from custody. Some of these will eventually make their way to the Supreme Court.
There are a number of cases involving big technology companies, and these mostly revolve around monopoly, tax evasion, copyright infringement, anti-competitive activities, and we're still waiting on a Google versus Oracle opinion. Is it possible that any of these technology giants are likely to be broken up, or would any of these cases change the way technology develops in the future?
There are antitrust suits being initiated, for example, against Facebook. My field is United States constitutional law, not antitrust law. So I can't express an opinion in terms of how likely it is those antitrust suits are to succeed.
Okay. Well, then let's back off and let's move over to, there have been some strategists claiming, we're going to go back to court composition, claiming that Joe Biden's potential nominating of Merrick Garland to become the Attorney General would vacate his seat to allow a spot to prep a new potential Supreme Court justice. What's your take on that?
Merrick Garland. Yeah,
and
please.
Thank you, Michael. That's a terrific question, Michael Pappas.
Sure. Merrick Garland's resignation from the DC Circuit will create a vacancy on that court. I don't think it's coincidental that Joe Biden waited until after the Georgia runoff elections to announce Merrick Garland to be the new Attorney General. I think had the Republicans taken one of those 2 seats in Georgia and kept a Republican majority, Biden would have picked somebody else to be Attorney General. Because if there was a Republican Senate majority, he wouldn't know whether or not they would confirm his nominees, say for the DC Circuit. But now with a Democratic majority, he can be confident he can replace it. The DC Circuit has produced many Supreme Court justices. Brett Kavanaugh was on the DC Circuit. Ruth Bader Ginsburg was on the DC Circuit, John Roberts was on the DC Circuit, Clarence Thomas was on the DC Circuit, Antonin Scalia was on the DC Circuit. So it's certainly possible that one of the judges on the DC Circuit could be elevated to the Supreme Court, but so could Federal Court of Appeals judges from anywhere in the country, state Supreme Court justices, state court judges, or even people who have never been judges can be put on the Supreme Court. Obviously, whoever's picked to replace Garland is a possible Supreme Court nominee, but I want to say there's many people on the DC Circuit now who have the age and credentials to be considered for the Supreme Court. The Chief Judge, Sri Srinivasan, has impeccable credentials. Judges Nina Pollard, Patty Millett on the DC Circuit. But the answer to the question is yes, whoever's appointed to replace Garland could certainly be somebody to consider for the Supreme Court.
A question comes in from our own Jason Sadow, and it's back on the conversation of COVID-19. And President Trump deferred to governors to take action. If President Biden attempts to take federal action, rather than leaving it to the states, are there limitations on the federal government that the Supreme Court might impose?
There's both the question of what's the statutory authority and what's the constitutional authority and what are the constitutional limits. In terms of statutory authority, under the Public Health Act, the government can take actions that are needed to stop the spread of communicable disease between the states and from coming into the United States. That's why President Trump could not order the opening of businesses, because that wouldn't relate to or help to stop the spread of a communicable disease between the states or into the country. But that's what the federal government can do. It's broad power to stop the spread of communicable disease between the states or from coming into the country. Also, of course, one of the things the federal government can do is coordinate the availability of supplies, such as protective health equipment and their distribution. And the federal government is the one, through the FDA, that's to approve the vaccines, and hopefully they'll do a much better job of getting it out to people than what we've seen over the last few weeks. Congress has the power to regulate commerce among the states. And so Congress could adopt laws that give the president and the executive branch more authority to take actions with regard to this, stopping the spread of communicable disease. But all of this is potentially limited by the Constitution. Obviously, none of this can be done in a way that violates constitutional rights. That said, courts generally give the government a great deal of latitude, especially in a pandemic, to stop the spread of a communicable disease.
So we're running close to the end of time, and before I go crazy with, there's a lot of questions, and there's questions about property rights, and in fact, let's go into that property right question.
Sure.
Okay, there is a question about fracking. So if the federal government bans fracking, specifically the rights of fracking on private property or privately owned land, will the court require compensation to the owners for the loss of their leases to drillers?
It's a great question. The Constitution says that the government can take private property for public use, but it must pay just compensation. There are two ways of finding a taking. One is if the government literally takes ownership of the property, it confiscates the property. It's called a possessory taking. That's not involved here. The other is where the government regulation prevents the development of property. And that's what's involved here. If the government says that there can't be fracking, it's a government regulation. And the government, through regulation, often limits how property can be used. Zoning ordinances do that all the time. Environmental laws do that. The key case is Penn Central versus New York City, which says that so long as the government's action is on balance reasonable, it shouldn't be regarded as a taking that requires just compensation. And I think that the question for the courts would be, is the prohibition of fracking something that should be regarded as reasonable? There's a famous case from the 1920s where the government required that trees be taken down to stop the spread of a tree disease, cedar rust. And the court said, that's not a taking that requires compensation because it was needed for the public health. I think that's what the court's going to have to decide with regard to fracking. I don't know what the ultimate answer will be, but that's what the legal principle would be. Those are the precedents that would be applied.
Okay, there's a lot more questions, but I'm gonna raise a topic that I'd like to discuss with you. I want to talk about the state of our democracy. There's a number of questions that are coming in about public institutions are being very much affected by extreme public distrust. There's on top of that massive division between political parties and beliefs, and not only do people disagree with each other, if you disagree, you're now considered evil or the enemy instead of just having a different opinion. What do you expect from the Supreme Court, and what could the Supreme Court do, or are they likely to overcome this issue, and what would you hope to see from a President Biden on this topic?
Let me try to take that step by step. First, in terms of democracy, we've just witnessed the greatest threat to American democracy in United States history. That's not hyperbole. From 1800, when John Adams was denied re-election, through 1992, when George H.W. Bush was defeated, every incumbent president who lost for re-election simply said that there'll be a peaceful transition of power. Never before have we seen what we witnessed in the last couple of months. Never before have we seen a president trying to strong-arm election officials in Georgia and Michigan to not certify the popular vote. Never before have we seen a president try to persuade legislators in Michigan and Pennsylvania to ignore the popular vote. Never before have we seen a president try to pressure the vice president to not count the electoral votes. But I think all of us today should also be reassured that the guardrails of democracy worked, that despite a pandemic, a record number of people voted. There was no evidence of fraud, no evidence of foreign interference, that the election officials, Democratic and Republican, withstood the pressure and accurately counted and reported the votes, that the courts, state and federal, both Republican and Democratic appointed judges, withstood the popular pressure. And they all said, there were over 60 cases, there was no evidence of fraud and no legal basis for overturning the election. And ultimately, the House and the Senate and the Vice President did certify the election. I think we saw our democracy as more fragile than we ever could have imagined, but it withstood the assault. Now I think we need to focus on what can we do to strengthen the democracy for the future. Second, in terms of the deep public divide, there's no doubt that it exists. My hope is that the Biden presidency will tone down the rhetoric and look for bipartisanship wherever possible. We saw on Wednesday the real risk when we unleash the kind of forces that have been unleashed recently, that when we play with that kind of fire, it's truly dangerous. And I hope that the Biden administration will pursue bipartisanship and that Republicans and Democrats will do so as well. In terms of the Supreme Court, my hope is that it will move incrementally, that it will be minimalist rather than pursue grand conservative agendas. It's such a difficult time for our country, but I believe there can be healing.
So I'm going to ask a difficult and pessimistic question. With the Supreme Court firmly conservative leaning and the Congress and executive branch firmly left-leaning, what is the likelihood of bipartisan cooperation?
I want to talk about two parts to that. One is the president and Congress engaging in bipartisan cooperation, and then the other is what happens with regard to the Supreme Court. Recent experience should cause us to be pessimistic that there can be bipartisan cooperation in Congress. After all, when Barack Obama took office, the Republicans said their goal was to make sure that he completely failed. Mitch McConnell said that explicitly and verbatim. every Republican in Congress voted against the Affordable Care Act. There was no effort at bipartisanship. My hope is that maybe the experience of the last 4 years and what we saw on Wednesday points to the tremendous dangers if we continue down the current road. And my hope is that that will inspire much more in the way of bipartisanship than we've seen in recent years. In terms of the Supreme Court, I am worried that some Democratic initiatives might be struck down by the Supreme Court. And that's why I say, as well as for healing, I hope that the court goes slowly, incrementally, in a minimalist way.
Okay. I do see we are just about out of time. And what I'm going to do is I think what you just said is a perfect way to end the conversation. Dean Chemerinsky, I appreciate your comments and your wisdom today. It is an incredibly timely conversation that we had today. And when we scheduled this, there was no way for us to know of just how important your words and your comments. And I can tell you on behalf of the Economic Club, we thank you for your information and your perspective. And I can only hope that your comments get to the Senate, to the House of Representatives, to the executive branch currently and in the next 4 years, and to the Supreme Court justices. Thank you, and Berkeley Law School is very lucky to have you.
That's so kind of you. Thank you for having me, and thanks to everyone for listening in today.
Thank you for these terrific questions. You guys were fantastic. Stay tuned to the Economic Club. The replay will be available on both our website, on our YouTube channel, and future events will be booked shortly. Thank you, and everyone have a great day and stay safe.